In addition, segments of this will be shared on social media and other venues. Just thought I'd give you a heads up on that. So, also in addition to that, there will be people joining us on Zoom during the day that could not make it. My president, Mike Parker, called me this morning early and said, there's 3 inches of ice in our driveway, so I'll be there when I can get there. He's gonna help me with the event. I have a horrible cold, a chest cold, so don't get near me if you don't wanna catch it. With that, I wanna get started. As many of you know, red flag, yellow flag is a very controversial issue. When this policy was first promoted, I want to share with you where it came from. A red flag, traditional red flag bill passed the legislature and was vetoed by Governor LePage. In the next cycle, Janet Mills, our current governor, was elected, and a bill was introduced that had more Republican co-sponsors on a red flag bill than it had Democrats. In addition, Donald Trump, our current president, was speaking positively about red flag. At that time, I went to Governor Mills and said, we have serious issues with red flag, due process, and other components of that, and said, would you be interested in talking with us about creating a policy that meets due process standards, could stand up in a constitutional challenge, and something that's focused not on guns, but on helping people when they need help the most. So that's where the committee came in, the Judiciary Committee, and we started meeting. The players who were involved in those discussions were some of the most respected legal minds in our state. Then Senator Carpenter, now a probate judge, who chaired the committee, was originally in favor of red flag, led the negotiations along with Derek Langhauser, who now teaches at the university, teaches law. Let me just shut this off before I call it. Not only Derek Langhauser, but Brian McMaster, who just retired from the Attorney General's office, John Chapman, a very strong pro-Second Amendment attorney out of Portland. Together, along with Senator Kine, who sponsored the so-called Yellow Flag Amendment, we began to meet, and we met for almost a month and came up with a bill that we believed met constitutional muster. This is how our system works. When the legislature says they want something, you can either engage and try to mitigate any negative impacts, or you can stand on the sideline and live with what they come up with. When we injected ourselves into this process, me, Sam, we knew our goal was to first protect public safety, but more importantly, if we did pass a bill, that it would protect individual freedoms, particularly due process. So that's where this started. That bill did get passed, and I think Senator Kine just came in. Any legislators who want to come up front when things are happening, I'd love to engage during this presentation. The 2 people that are here today are under invitation from us who deal with this law every day. Michael Johnson, I believe.
Yes.
Yes. Their troop, or their division, has conducted more yellow flags than any other in the state. He'll be speaking to that in a minute. But I think the real asset to us here today, both their knowledge, experience, but Mr. Strick actually conducts, or his Spurwink company conducts the mental health component of yellow flags. This is your opportunity to learn the facts about how the law works, to put aside the political talk and rhetoric that you hear outside of this place. These people know how the law works. They deal with it every day. So now's your chance. You want to learn how it's used? This is your opportunity. So with that, I'm going to turn it over to one of you to begin your presentation, and we'll take questions at the end.
Thank you, David. Maybe some introductions, a little bit about myself, and then Ben can talk a little bit about himself before we get started. So
could you just use the podium?
Sure,
Thank you.
sure. Good morning. Thank you for having us. Michael Johnston, I'm a lieutenant with the Maine State Police. I'm commander of the Northern Field Troops. So I oversee uniform state police operations for a 4-county area: Penobscot, Hancock, Washington, and Piscataquis. So I think we'll talk about some numbers in the application of this law, but just so you kind of know why I'm here. So since this law has been in effect July 1st of 2020, the state police have successfully used this law 61 times. That's more than any other law enforcement agency in the state. And my troop has done 37 of those 61. So my troopers have utilized it a lot, particularly post-Lewiston. So I've been with the state police just over 23 years, and in that time dealt with various policy, legislative issues, and obviously now I execute those operations with my troopers in the Northern Field Troop.
Hello, my name is Ben Streck. I'm the Vice President of Adult Behavioral Health for Sperming Services. We provide 24/7 telehealth access for the weapons restriction assessments, the assessment by a medical practitioner component. As of last night, we've done 642. David has thankfully posted all of the assessments from the most recently published list, so you're able to see those. To be clear, I'm not here to take a position on one side or the other, but I'm able to answer any questions that you might have about how the process works, what we've seen, and collaboration with law enforcement. We have a presentation. We kind of have two general presentations that we give. One for law enforcement on how to use it, another for the general public on how the law works. This is a bit of a hybrid between the two. We're not going to follow the slides religiously, but we may use it as a guide. And then I think I just had to add this slide.
Thank you, Ben. So this is the first time we've co-presented, although he's a pro, I've seen him present many times before, so hopefully it's not, it's seamless. So Ben mentioned some of the numbers, and I think that's important because when I teach this primarily to law enforcement, but I think this is true for everyone, we live in a post-Lewiston world, for all that means. And when I look at it from a law enforcement perspective, what that means in terms of our public safety responsibilities, but certainly with respect to the application of this law and the importance of this law. So I think my numbers are correct. I think we successfully utilized this law from July, when it went into effect, July of 2020, up until the Lewiston incident. It was successfully used 81 times. Since then, I think it's been used 609 times. So Ben mentioned that what Spurwink has done, and they're the lion's share. They were a game changer. But overall, it's been 690 times, and 609 of those have been since Lewiston. So 3.5 years, 81. In the last less than a year and a half, that's the numbers you've had. That's unbelievable. And I think that speaks to the application of this law, the law itself, law enforcement and medical practitioners in the community buying in to the public safety aspects of that, and that's why you see so many. So that kind of sets the stage for when I say we're in a post-Lewiston world. And we're really going to talk about kind of the nuts and bolts of this law. I'll try not to get into kind of too much in the weeds in terms of law enforcement, but I'm certainly open to any questions you have about that process. But kind of the nuts and bolts specifically related to what protective custody is, probable cause to get to protective custody, and the importance of relying on third-party information as part of the application of this law, which would be all of you folks. Before I do that though, sometimes I find it's helpful to clarify when you talk about mental health and firearms, and I know I'm speaking to an audience of sportsmen and hunters where you're all very knowledgeable about firearms, but I know there's some confusion, I certainly know there is in law enforcement. So you hear yellow flag, red flag, blue paper, white paper, you have an intersection between mental health and firearms, and I want to start with when you're actually prohibited from possessing a firearm as a result of your mental health. So I'm going to throw out some statutes, and they'll reference them here in the PowerPoint. But you're in the Mental Health Code, Title 34B, and you start with 3862. That is the protective custody statute. We're going to come back to that. And then you go next door is 3862A, which is the yellow flag. Now, yellow flag is not a legal term, it's a colloquial term. They're called extreme risk protection orders. or we call them weapon restriction orders, but the official name of the statute is ERPO. It changed, it was protection from substantial threats, and then it changed August 1st. We're going to come back to that. We're going to go to 3863. 3863 is an emergency and voluntary hospitalization statute, where a person, if they present at a hospital through a couple different means, but let's say law enforcement brings them into protective custody, a medical practitioner can do an evaluation, and in their expert medical opinion and diagnosis could determine that they need to be involuntarily admitted on an emergency basis to be treated. And Ben can probably speak to that process far better than I can. But once you're blue papered, the medical practitioner has to fill out an application, a judge or justice of the peace has to endorse it, and once they're endorsed, they can be held for a period of time. I think it's 72 hours, after which, if they want to continue to be held, they have to have a hearing, so there's a due process element. If you've been blue papered, you are not prohibited from possessing firearms. You used to be under federal law, under the Gun Control Act, under 922G, U.S. Code 18, up until you had the Raylander decision in 2010. That was a First Circuit decision that said you'd never be prohibited for blue paper under state law, but under federal law, they said you were up until 2010, and they said, no, you're not. So blue paper, you do not lose your firearm rights. It might be prudent and reasonable to make sure you don't have access to firearms until you get treatment, and that can be done by working with family, but as a matter of law, you are not prohibited. So, if they want to continue to hold you after that time period, they have to have a hearing before a judge. There's a due process element. So, they have a hearing before a judge, and the hospital represents one side, and I'm oversimplifying this, and then I don't want to call them the defendant because they have committed a crime, but the patient is represented by counsel, and you have a hearing before a judge to determine, do we need to continue to hold this person for up to the next 21 days? And after that hearing, if a judge determines that they feel that the person should continue to be involuntarily held and enters a judgment, they have then been white papered. Once you have been white papered, you are prohibited for life from owning or possessing firearms under both state law, under Title 34B, 3864, and Title 15393, and federal law, once you've been white papered. So there's no yellow flag yet here. This is all just laws that existed before yellow flag that still exist now. So that is what a white paper is. I don't think there are a ton of white papers. I don't know what the frequency is, but it is a process that does exist. Yellow flag, we'll get into that next. Red flag, I think you've heard it talked about. That is, Maine does not have a red flag, but I think all of you know red flag, essentially what it means is who can initiate the process for this weapons restriction order. A yellow flag is limited to law enforcement. Law enforcement initiates this process. In some other states, like New York, you have a red flag where multiple people can petition the court for a weapons restriction order. So that's kind of the main difference. There's some other differences, but that's really the main one, is how does this get initiated and how does this happen? Maine, it's through law enforcement, with the information and help of family members and friends and concerned people. So does that make sense on the firearms and the white paper, blue paper, all the different color kaleidoscope? Any questions on that? Yes, please.
So I put up on the screen the definition, the statutory definition of a mentally ill person. And so we're going to get into that a little bit more. But what you'll see is it's not a diagnosis. It's more akin to a collection of behaviors that includes a person suffering the effects of substance use and a person in crisis. There are a couple of rule outs. We'll get into those rule outs more later. But I think that's one of the areas where we have a lot of confusion, is that there has to be a diagnosis. This person has to have a clear mental illness. If you look at this, and then you compare it with the weapons restrictions that you see, you understand a little bit better how things fit together. Questions about that? This is the same standard for a blue paper, an emergency and voluntary hospitalization. So you have protective custody, probable cause a person is a mentally ill person who poses a likelihood of serious harm, and then hospitals have the same criteria for the blue paper.
Thank you. Okay, so I told you we'd kind of come back to 3862 in protective custody. So protective custody is a necessary threshold element to initiate this process. If you don't have protective custody, it doesn't happen. Now, there was a change in August 1st where it extended the time frame in which these evaluations and applications can take place. But it's important to remember that law enforcement and protective custody is how this process is initiated. If someone were to present at a hospital, or a family member were to bring them in, it doesn't happen unless law enforcement comes, fills out the application, and presents it to a medical practitioner, which is 99 times out of 100. Can't imagine any other way we do it with Spurwink. So law enforcement and protective custody. So protective custody is a statute, 34B 3862, that has been around for a long time. It's been around at least as long as I've been in law enforcement. And essentially what it says, and we'll get into the legal terms, that if law enforcement has probable cause to believe that based on a mental illness, that you present a likelihood of serious harm to yourself or others, we can take you into protective custody. I don't like to use the term arrest, but to keep it simple, it's almost like a mental health arrest, but I don't want to make it sound like we're criminalizing mental health. But we can, sometimes it looks like an arrest. We try to work with them and be cooperative, but sometimes they have to go. We have to use a reasonable degree of force to do it. But we can take them into custody to deliver them to a medical practitioner like Ben, who's a subject matter expert, to do an evaluation.
Would just add, I don't qualify as a medical practitioner.
Gotcha. Well, he's still an expert. So we would take them to a medical practitioner where they would be evaluated. That assessment, that mental illness that he put up there in our assessment, is a layperson assessment. When I go there as a police officer or a private citizen is saying, I have concerns about my parent, my child, a family member, or friend, that to satisfy that prong under protective custody, that's a layperson assessment. As much as I like to think I'm really smart and I know everything, when I'm making this mental illness, that's as a layperson. All right, that's a common sense approach of what I think a mental illness is. The experts, the medical practitioner, they're going to make the medical practitioner assessment under the statute. So, likelihood of serious harm. Basically, do I have probable cause to believe that you're a danger to yourself or others? Are you suicidal, where you may kill yourself, or may you kill somebody else, or are you a danger to inflict serious bodily injury on somebody else? Okay, that's essentially what it means. Now, probable cause. How is that developed? Probable cause is a term that we're very familiar with in law enforcement because it's the burden of proof that you need to justify making a criminal arrest or getting a search warrant. Okay? It's a very workable standard in the field. And I think Ben has the definition up here, but I'm going to try to remember it from when I was in the academy without looking. It's a little different. But basically, probable cause, and I'll give you the street definition. Those facts and circumstances within an officer's knowledge of which he has reasonable, trustworthy information sufficient in themselves to warrant a person of reasonable caution in the belief that a person has a mental illness and poses a likelihood of serious harm to themselves. That's essentially what it is. Now, what does that mean? It's a fair probability. All right, it's a fair probability. On the spectrum of evidence scale, it is probably somewhere between 30 and 50%, probably closer to 35-40%. So the way I look at it is I have, at the very beginning, reasonable doubt. That's what you need to inject in a criminal trial in order to be found not guilty. Next up from that, you have reasonable articulable suspicion. That is a legal term in law enforcement that we use to justify doing an investigative style detention. Next up to that is probable cause, what you need to make an arrest. Up from that is proof by a preponderance of the evidence. That is more likely than not. That's 51%. Next to that, you have clear and convincing evidence, which is important because that's the standard of proof you need to meet to get me restricted for a year. And then you have beyond a reasonable doubt, which is the burden of proof you need to meet in a criminal trial. And then you have absolute certainty, which you never have in law enforcement.
So, how do you do, guys? Pretty darn good.
Okay, yeah, so that's kind of the spectrum of evidence scale that we
I want to
use.
jump in here real
Yes.
quick. This is a key element of the difference between red and yellow flag. Under a red flag, they use lower due process standards when taking a person's rights. Clear and convincing evidence is, as you can see, a pretty high standard. And that's the terminology that's used in our law. And it is kind of the point of contention in battling.
I think The clear and convincing evidence is for an extended restriction. The initial restriction is where the difference is. Are you
Yes,
comfortable with me going into that?
Yeah, I would like to see you do that, because this is a part where it's easy to get confused if you don't understand the differences between these standards.
Sure.
So reasonable articulable suspicion is a traffic stop. That's one way to think about it. Probable cause is what you need to start a weapons restriction process, to take a person into protective custody. And it's what a reasonable person would believe given the facts and circumstances. And so you are all reasonable people. So that's the standard that law enforcement needs to establish. They need to have clear facts and circumstances that allow them to do that. The difference between red flag and yellow flag, and I'm not weighing in on one side or another, is how you get to that initial restriction. So in Maine, that initial restriction involves protective custody and then an assessment by a medical practitioner. And then within 30 days, you go before a judge for an extended restriction. And that extended restriction can be up to a year. That's where the district attorney needs to demonstrate clear and convincing evidence to extend the restriction. For red flag, the initial restriction can be based on a layperson going to a judge. Oh, I got John Chapman here. He's probably going to yell at me for something. Do you want me to put you on speaker, sir? All right, I've got John Chapman, my former neighbor, on the phone here. So, John, what I'm explaining is the difference between an initial restriction and an extended restriction and how that plays into due process. So that the initial restriction in Maine involves protective custody and assessment by a medical practitioner. In red flag, there isn't those two steps. It goes to the initial restriction, but then you still have the clear and convincing evidence for the extended restriction.
Sure. By the way, just for everybody in the room, Ben is truly a rock star in this area, and I've been very impressed by him as more than a neighbor.
Thank you, sir.
No, but to stay on that point, I guess, is, so probable cause is the burden of proof that you need to initiate this process. There's a gap between probable cause and clear and convincing evidence. So your initial period of restrictions, which can be up for 30 days after which you have a hearing, it means that you may be able to get an initial period of restrictions of 30 days, but you may never have the evidence that you need to prevail at a hearing. So there could be various reasons why you get an initial period of restrictions for 30 days, but you either don't prevail at a hearing, or a DA decides not to file a petition at a hearing because they feel that they can't meet that burden of proof to prevail. So there are reasons why you may only get a 30-day initial period, but you don't prevail at hearing, and they don't get the year-long restriction. That 30-day period is still very valuable. That's incredibly valuable when you look at the people that are in crisis that this law is being applied on. That still provides time, a cooling off period, a time for treatment, a time for them to get some help, regardless of whether or not they're going to be restricted for the full year, or the DA and council come to an agreement where they decide we're going to do it for maybe 5 or 6 months. But anytime you have a gap between what law enforcement is doing in the field and what may happen in a courtroom, it doesn't mean that the initial period of restrictions weren't legally righteous. It was, but probable cause is different than clear and convincing evidence. There's a pretty wide gulf between there. And you don't see clear and convincing in the criminal world, but this is a civil process, not a criminal process. It's a civil process with a criminal penalty, so you can't really apply the same terms. It's different in that respect. So that's why probable cause is important. It's what you need to initiate it and get it going, but you're going to need more when it goes to a hearing to meet that burden of proof.
May I add one thing?
Yes.
So I think that's one of the other important pieces for community members to understand, is that when you're working with law enforcement, when you're concerned, you need to be able to provide them with more information than simply saying, I'm concerned. We need to be able to help them establish the facts and circumstances that allow them to take somebody into protective custody. So much of the work I do with community providers and other community members is help them understand what it is you need to explain to law enforcement so they can do their job. Does that make sense?
So we talked about protective custody and probable cause and how you formulate probable cause. Well, probable cause can be formulated a number of different ways, but the protective custody statute specifically says that in law enforcement's formulation of probable cause, they can rely on credible and reliable third-party information. So if you speak to a family member or friend and they're providing credible and reliable first-hand observations of the person that they're concerned about, you can use that in developing your probable cause. The key is that it's credible and reliable. Probable cause can be based on hearsay. This hearing, you can use affidavits and hearsay information. It's a civil process. You can't use hearsay in a criminal trial unless there's an exception to the hearsay rule. But this is different. You're allowed to use that. So let me give you an example of I'll de-identify a situation in which you can see this actually works. Because in speaking with all of you folks, you're thinking, all right, you see people that may have undiagnosed, untreated mental illness, and unfortunately, we're at a point where, whether it's because of lack of community-based treatment sources or challenges in that field, you're almost like waiting for something bad to happen before you can take action. If you are seeing things that concern you, okay, then you call law enforcement and you speak to law enforcement and you tell them what your concerns are and you try to provide them as accurate and detailed information as possible based on your first-hand observation. This is how he or she is behaving, this is what they've said, this is what they may have posted on social media, and then we'll look at that and evaluate, okay, are we starting to get to maybe probable cause to believe this person is a danger to themselves or somebody else based on mental illness, okay? Now law enforcement's gonna follow up and probably do a welfare check, and they're gonna want to corroborate or supplement your observations with their own first-hand observations, but almost all the time it starts with a family member or friend being concerned and calling and reporting to law enforcement, and that call is so critical. That is incredibly critical. It's kind of like the kind of see something, say something campaign. If you see something that is concerning you, then call law enforcement. And I understand people may feel like, I don't want to call the cops on someone, this is a mental health issue, but like I said, we're in a post-Lewiston world. We're in a post-Lewiston landscape, and if you have concerns about that person, you need then report it to law enforcement, because law enforcement have the tool now with this law to be able to follow up, and if we meet the dangerous weapon component and the probable cause component, we can do a weapons restriction order application. So, give you a situation. We get a call, oftentimes these cases are initiated by family members, and it's key. It's a spouse, it's a parent, it's an adult child calling about a parent. It is so key to not only the reporting, but following this all the way through, dealing with the weapons relinquishment, dealing with the care of that person. We get a call from a woman who has an adult son that lives with her. And she is concerned because that person has a history of suicidal behavior. And she's noticed changes in her son's behavior. So adult son lives with her, and she reports that to law enforcement. Law enforcement may speak to her on the phone or speak to dispatch. They may go to the residence and do a sit-down conversation with her and say, why are you concerned? Well, he just got done work, he lost his job, I noticed he doesn't he's not doing his normal activities, he's tried to commit suicide in the past by overdosing on pills, he's talked about life isn't worth living, he hasn't been very specific necessarily about how he's going to do it, but I'm very concerned, and I've observed him over the past 3 or 4 weeks. Now, would you say that the mother is just on its face would be a credible, reliable third party? Just without law enforcement training, just common sense, credible and reliable third party. The information she's providing is that have some specificity to it about the person's behavior. Would you say that yes, I've got a concern, this person maybe has a mental illness, there may be a danger to themselves, just common sense, reasonable person? Would you say yes? Yes. Now, whether you're at probable cause or you're scratching at the door of probable cause, this is a third party that's reporting to law enforcement. Now, law enforcement goes and speaks to her and then wants to talk to the subject, talks to the subject at the table, confirms that this gets additional information. This person says, yeah, life isn't worth living, acts very despondent, things haven't been going my way lately, I've been thinking about killing myself, I'm not exactly sure how I'm going to do it, but I really have been thinking about taking my life. Okay, without going into other details, is there a fair probability that you believe that that person has a mental illness and that they're a danger to themselves? Yes or no? Yes. The answer is yes. That's probable cause in a basic workmanlike form, okay? Now, there's an additional component about the dangerous weapon, and I don't know if we want to talk about that, Ben. I don't know if I'm getting ahead of myself. I don't want to brush over the probable cause third party if we want to get into the dangerous weapon component.
So I think at this point, this is a lot of the education we do with
Yes.
law enforcement. So at this point, you've established probable cause. This is a mentally ill person who poses a likelihood of serious harm. Does that make sense? So now, law enforcement is able to take that person into protective custody. If they take somebody into protective custody, and it's law enforcement may, so if they do, they have to deliver that person for assessment by a medical practitioner. So once we've established all of those things, there's one more thing that you need to meet for a weapons restriction. Probable cause the person possesses, controls, or may acquire a dangerous weapon. Now, is this somebody that you would be concerned about having access to a weapon at this point? So you need to ask a few more questions.
Yeah, so we've established we have protective custody and probable cause. And now we're gonna, like Ben said, we're gonna talk about the dangerous weapon component. If there's no dangerous weapon component, then this is like the protective custody statute that has existed for a long time. You can take the person in protective custody, deliver them to a medical practitioner to be evaluated for treatment and evaluation, which might lead to a blue paper, might lead to outpatient treatment, whatever. Whether taking them into protective custody is a discretionary act, the statute says may. If there's no dangerous weapon component, you're in the may territory, you're not compulsory, it's not a shall, okay? So you may decide to take that person in protective custody, you may not. If they're willing to go with their mom and dad, or willing to go in the back of an ambulance, then there's no sense of having law enforcement try to necessarily aggravate the situation or escalate it when it might not be necessary. They're willing to go to the hospital, see a medical practitioner, get evaluated. That is the key. Now, the dangerous weapon component, as Ben said. So the yellow flag statute, 3862A, it's right next door to protective custody. It's a good fit for it. There's a definition in there. It's a definition, but it's really important. It's under 3862-A, subsection 1, paragraph K. It defines a restricted person, and this is key. If you have probable cause to take a person in protective custody because they present a likelihood of foreseeable harm, and you have probable cause to believe that they possess, control, or will acquire a dangerous weapon, yellow flag. Now it's not discretionary, it's a shall. You shall take them into protective custody, and you shall fill out a weapons restriction order application. Okay? Now, law enforcement is always going to have a certain amount of discretion to deal with the situation because the laws are black and white. We live in a world of gray where you need that discretion. But just legally speaking, generally speaking, law enforcement, you shall take them into protective custody. It's no longer a discretionary act. Again, post-Lewiston world, with all the liability and public safety concerns, you're going to do a weapons restriction order. Now, a little bit about what constitutes possession, control, and acquire, because these are important terms and they're kind of legal terms of art in terms of what they mean. Possession is just what it sounds like. It's actual possession. You have a dangerous weapon on or about your person that's readily available. Control is another word for constructive possession. Constructive possession is basically you have knowledge of the dangerous weapon and the ability to exercise control over it. Acquire is just that. You've indicated, based on the information, your intent to acquire a dangerous weapon. So those are kind of the three terms. Now, this law applies to possession, not ownership. Okay? You can possess something and not own it. And you can have an ownership interest in something without necessarily a possessory interest. I know that seems a little weird, but ownership, I think, is a component to determining possession, but you don't need to own something to possess it. This law applies to possession. That's key, is that it's possession. What is a dangerous weapon? A firearm is always a dangerous weapon. So if a dangerous weapon has a very specific definition in the criminal code, it's under 17A, section 2, subsection 9, paragraph C. Dangerous weapon always includes a firearm. Anything else could be a dangerous weapon based on the manner in which it's threatened to be used, and based on that can cause death or serious bodily injury. A baseball bat is not a dangerous weapon unless you threaten to hit someone with it. Then it becomes a dangerous weapon. A steak knife is not a default dangerous weapon unless you threaten to stab someone with it. Then it becomes a dangerous weapon. A firearm is always a dangerous weapon under Maine statute. We good on that so far? Okay. So, made the determination at the house, talk to the person, clearly suicidal. How do I determine the dangerous weapon? How do I determine that at the time I'm dealing with them, they possess, control, or will acquire a dangerous weapon? Well, you have to do an investigation and ask questions. You know, you may ask them, do you have any firearms in the residence that you have access or you possess? And then see what they say. Are there other dangerous, if you're asking them how are they going to commit suicide, have they thought about it? Have they thought how they're going to do it? And they indicate that, yeah, they're going to go and they're going to get a knife and they're going to stab themselves. Or they're going to go and try to acquire a firearm. Then that would satisfy that element. So you're going to have to speak to them. You're going to have to see if there are any things in plain view that I would consider to be a dangerous weapon. The key thing that and this is more for law enforcement, but it's a key thing. You don't need to show that you have probable cause to believe they are going to use a dangerous weapon to kill themselves or hurt somebody else. There's not a causation element in here. There's probable cause to believe mentally ill, danger themselves or others, and probable cause to believe that you possess or control a dangerous weapon. So let me give you an example of that same. Or may acquire. May acquire. They may. If I had someone that is a danger to themselves, they don't indicate they possess a dangerous weapon. I have no evidence to indicate to the contrary. But in telling me, well, I'm going to go out and commit another Lewiston. Well, by inference, a Lewiston was obviously committed with a firearm. That would satisfy the probable cause problem. If they're referencing going out and engaging in an incident that we know factually involved the use of a firearm, from a law enforcement perspective, then I would consider, yes, you have indicated your intent to acquire a dangerous weapon, to wit, a firearm, and I'm going to use this law is going to be applied. To get back to the scenario I was talking about, where adult son living with a mother, concerned about suicidal behavior, he reaffirms that, he talks about it, you've established protective custody, mentally ill, danger to himself. In speaking with that subject, let's say that yes, I own a handgun. I keep it upstairs. It's my handgun. Said, I would never use it to shoot myself, I would never do that. But I have a handgun. Okay, let's stop here. We've agreed we have probable cause, protective custody. Now, common sense, reasonable person. Do we have probable cause to believe that person possesses, controls, or will acquire a dangerous weapon? Yes. That's a yellow flag. That's a yellow flag. That didn't happen in this case. If they indicated, I'm going to take a knife and I'm going to slit my wrists. Stop there. Probable cause to believe that they're mentally ill and a danger to themselves? Yes. Probable cause to believe that they possess, control, or will acquire a dangerous weapon? If you take a knife and you slit your wrist, is that in the manner in which it's threatened to be used to cause death or serious bodily injury? Yes, that's a yellow flag. Now, the downstream question, are we taking every bladed thing in the house? Not necessarily that's a reasonableness, but that they've indicated their intent to acquire something that in the manner in which it's threatened to be used is a dangerous weapon. That's a yellow flag. For law enforcement in the field, probable cause, we're going to fill out an application. Is everyone with me so far?
It's been used to take machetes and swords.
Oh, yeah.
Go ahead.
Yeah, could you just clarify a little bit more the may acquire part? It seems kind of subtle, but do they have to express that they intend to acquire?
Yeah,
or is there some gray in there?
Well, so you need to have probable cause to believe that they possess, control, or will acquire a dangerous weapon. So you need to have detailed information that they have an intention to go out and acquire a dangerous weapon. So that can be discovered a variety of ways. Mostly it's discovered by speaking with the person. How do you satisfy that element? But if they indicate to you their intent to go out and acquire a dangerous weapon by telling you or referencing they're going to engage in an act that where a dangerous weapon was used, then that's probably going to satisfy that problem.
But it can't just be assumed?
No. Probable cause. So probable cause we talked about. It can't be an unspecified hunch. It can be based on your spidey sense. Okay, probable cause. You need to have specific facts and circumstances, which you can draw inferences from based on your training, education, experience. But you can't just make an unspecified hunch or, well, I think they're going to do it. No, it needs to be grounded based on the evidence that you have in front of you, which could be a statement from them, a statement from a third party, could be based on text messages, social media postings. It needs to be grounded in that in that soil of information. Does that make sense?
Yeah, thank you.
An example of that might be, I'm gonna go get Uncle Joe's gun and kill myself. Or
Yes.
That's
All
an
day long.
example of may acquire. It's a
Yeah,
simple-
that's obvious, but
Yeah.
Yes, all day long, exactly, that's,
So I think the all day long is really one of the essential points of this, is when you look at the list, it's all day long. You know, these are not questionable circumstances. There's nothing that's gray or ambiguous in any of the weapons restrictions that we've seen. These are based on probable cause statements from law enforcement. They're not going to come to us unless they've already established that probable cause. And so in this case, that idea of I'm gonna go and get Uncle Joe's gun, or I'm going to the store, oftentimes we've got text messages or social media posts that are part of that probable cause statement that are being delivered to us. So law enforcement is doing a truly incredible job of gathering and packaging this information, and then we're able to see it and say, oh yeah, this makes sense. This is really, really clear. But I encourage everybody who's really looking at the weapons restriction process to take a look at the list, because there's nothing on that list that anybody here will have any questions about.
That list was provided by the Attorney General's office.
So let me give you another example of kind of a third-party report that of this, that when we didn't actually have an encounter with the patient. I'll use the word patient because, you know, while you can initiate this process, while there's also criminal liability, it's not an either or, but a lot of times there's not necessarily any criminal liability, it's just mental health. So we dealt with a call where we, a family member, I think it might have been a sister, was concerned about her brother. So she's an adult, he's an adult. She calls up and says, I've been communicating with my brother via text message, and he said some things over text message that are very concerning and indicated that he may be a danger to himself or other people, and talking about a weapon. So we go and we speak to her, and she shows us the text messages where the person has talked about that he might hurt himself or might hurt others, and he might use a knife to do it. Okay, so he's telling her this, and she's also telling us that he has substance use disorder, mental health, so he has co-occurring disorder, and you know, she gives very detailed information to law enforcement. So law enforcement goes and interviews her. She lives in Hancock County, and this person's last known address, I think, was in Penobscot County. Kind of a transient, not sure. So, but she tells us this, and she gives us this information. Yes, yes. And so we talk to her, we see the text messages. So again, probable cause, fair probability, something less than 50%, common sense, reasonableness. Sister showing text messages from her brother that indicates that he's thinking about killing himself or hurting others, might use a weapon to do it, and she also provides background on his mental health status. Do you think that based on that, you have probable cause to believe that this brother is a danger to himself or others?
Sure.
Yes, we determined we did. We haven't spoken with the brother yet, but it was so, the text messages and the sister, recent communications, and is there a fair probability? Yes. So, and we don't need to get into the protective custody order unless you want to, Ben, but this involved the use of the new protective custody order. We wanted to find him and check his welfare, and because we were concerned about him and others. So we initiated a search for him to try to find him, but we didn't have a good address and wasn't sure where he was. He was a transient. And that ultimately led to us using a new portion of the law, which went into effect August 1st, called the protective custody warrant, where we had probable cause to take the person into protective custody, and we wanted to do a yellow flag or weapons restriction order assessment, and we made a good faith effort to try to locate him in the areas that he was known to frequent, but couldn't. So how do we make sure that if law enforcement encounters him later that night, early that morning, the next day, they know that he's wanted for a weapons restriction order mental health assessment? And so we applied and received this new protective custody warrant, which they have, which is a provision to make sure that these things don't slip through the cracks. Yeah, sure.
So this is probably one of the coolest new changes in the statute. And this is the criteria for a protective custody warrant. You've made an attempt to take the person into protective custody. If you're not able to, then you can seek a warrant. The idea is that there were many instances, pre-Lewiston, where we had individuals that were refusing to come out of the house. And then what do you do in that situation? What we've seen is post-Lewiston and post-protective custody warrant, that this is a tool to help find people who are really struggling. So here's the idea, and it's a difference between the civil system and the criminal system, and I'm probably going to butcher this, so Lieutenant Johnson's going to be able to clarify it for me afterwards. But if you've got probable cause that somebody has committed a crime, you've got all kinds of options. You can detain or arrest them, you can force entry in certain situations, you can apply for a warrant. But prior to this change in the laws, if you have probable cause a person is mentally ill and poses a likelihood of serious harm, your option was to take them into protective custody. Now, if you're unable to take them into protective custody, you can apply for a protective custody warrant. That gets entered into the system like any other warrant, and it allows other agencies to then take that person into protective
Asterisk
custody.
that, I'll talk about that, about going in the
Fantastic.
system, but there's a solution, but I think it's a bridge to a more permanent solution.
But the coolest part of it is that we've seen people that are traveling between different areas, between different jurisdictions. And this allows you to initiate a protective custody warrant in one area and then have a law enforcement officer in another area take that person into protective custody. That wasn't the original design of this, but it's been a major improvement in the social safety net based on this very small change in the law.
Yeah, so the protective custody warrant is new. I don't think there have been very many of them. That's my troop's first experience with it.
6 or 7.
6 or 7, okay. So like with any new law, you kind of get used to it, and you kind of you get some reps under your belt, and to the extent that there may be some hiccups in it, then it might be something we have to come back and smooth out some stuff later. But in this case, it was very helpful. Absent this protective custody warrant, then really what you're left doing is just maybe sending out a teletype or trying to spread the word that you're looking for this guy, and if you find him, please contact us. But this warrant formalizes that process, and you put it into NCIC, so now there's a nationwide alert. So if a law enforcement from here to Timbuktu should happen to encounter him, they know that we are looking for him and that we have probable cause to take him into protective custody. And if you encounter him, please detain him, do it safely, and contact us to await further instructions. So it allows, it's a more formalized, comprehensive approach to these cases where you're not able to have contact or take the person into custody immediately, and it provides an option for that. Now, reference the entering into the warrant, I won't get into the weeds. I think there probably is a technology fix because they can't go into the criminal warrant database because they're not criminal warrants. So I think there's probably a technology solution somewhere behind the scenes between the courts and Metro and all those computer systems. We found a temporary solution. We enter them as a potentially missing or endangered adult, which they are, and it works for now. So that's just something that we'll have to address kind of later on.
So the question is, do you think it's a good idea to have something like this that allows people to communicate across jurisdictions? Right? Huge improvement, huge improvement.
And let me give you an example, kind of, I mentioned it practically. With this guy, we ended up locating him within 24 hours. Another law enforcement agency had contact with him in the area, and we were able to take him into protective custody. That PD actually took him to the hospital near them, called us, we met them, and we initiated this process. But let me give you an example. Let's say that 2 or 3 days went by, and he took a bus, and now he's down in Boston. And let's say he does something down there that causes law enforcement to have contact with him. Well, despite your best efforts to send out teletypes and this and that and emails, Boston's a busy PD and they deal with all sorts of stuff. Well, if they were to encounter this guy on, let's say, some sort of benign traffic stop or something like that, and they were to run him, you're going to have an alert that pops up. Says, hey, he has a protective custody, mental health, I call it a warrant. It's essentially a warrant the way you look at it. Take him into protective custody, contact the Maine State Police, and coordinate with them for further instruction. That is the key part of it. Before this law, that really doesn't happen. Or you're maybe counting on the fact that a police agency or law enforcement agency, is that it? Yeah.
Well, no, I was just going to say, here's an example. 671, 40-year-old New York man reported to be in Bar Harbor with a firearm and intention to kill himself, subject of a New York revote for homicidal and suicidal ideations, history of depression. And so, great use cross state lines.
And that addresses some of what was found in New York with the Robert Card situation where there's cross jurisdictions, military, police. This could be a way, if it was some sort of mutual agreement with other states, that these orders, if they are initiated, and I believe they should have been, maybe red flag in New York, yellow flag here, whatever, but that's where that communication can occur. And I know Senator Collins is working on this nationally with the military and others, a way to build that communications network across jurisdictions. But I see you've already started to address it.
Well, and the new law addresses it somewhat. I understand what you're saying, David. I think the initiative is to have a federal law that provides full faith and credit, similar to what we did to protection orders decades ago, something similar. But this law does, as part of the August 1st change, now recognize similar out-of-state weapons restriction orders.
Yes.
So now that helps us with law enforcement to say, to what extent are out-of-state ERPO laws enforceable or effective here? There was a change in the definition where they added language to say similar orders from other states. So I think that's a good step in the right direction.
Yeah. At this time, I want to jump in and ask the panelists to come up. I'd like you to stay here because your information is just invaluable. The next group of panelists, there's some of them here, John's on the phone. Where's Kim? I want to bring up on Zoom a couple of people that worked on it, and so I think they're waiting. Yes, John, and so if you could add that, Kim. The panelists, if you'd like to come up and sit up front, we're going to talk a little bit about when the law was created, and Mike, you can join me if you would. Just have a letter on Zoom here, and let Senator Carpenter know if he wants to join us. I'm going to ask Ben and Mike to stay to answer questions, because I do think that the following discussion, and I was one of them, John Chapman was another, Senator Kine, helped to negotiate and create this law. And a lot has been said, and very insulting to the people that worked on it. I want to go through who the individuals were that worked on this law. Derek Langhauser has been a lawyer that's represented the governor, multiple governors, administrations, was a key element of when creating this law. And then there was Brian McMaster in the Attorney General's office who helped write it. Former Attorney General Michael Carpenter, former Attorney General Janet Mills, Senator Kine. These were politicians, per se. They were some of the best legal minds in their state who came up with this law. And I don't know if you noticed in that description by the state police, there are pretty stringent legal standards that are followed. When, in the words of Derek Langhauser, when you take a person's personal liberty, you should have high due process standards. I will never forget his statement. You take somebody's liberty, you should have high due process standards, and I repeat that. So with that, I'm going to join Senator Kine. Mike, if you'll take over. Maybe you can tell your experience. John can tell a little bit about his and mine, and then some of the things that are being said that I think need to be addressed here. We will be facing a referendum on red flag, and a lot of things that have been said are just not true. So I think there might be an opportunity to clear up some of that. And I think, well, I know that I want to keep the state police and Ben out of the political side of this. They're here to offer information only, but their information is invaluable. And then I think after that, we'll get to a presentation by Justin from the NRA that will be highlighted to many of you. So I'm going to jump on the panel, and if you want to, yeah.
He's not going to be able to hear unless it's...
Okay. Just wait to get her technology going.
Well, I can start.
Yep, sure.
And your presentation, the two of you, that was amazing. And to be watching that and see how far this law has come from the origination point where it was a concept, right? This was going to work, but having the state get a contract with Spurwink was the piece that we needed for so many years because we had no way to get the mental health assessment. And so the moment of, starting this, right? And it's good to remember the history. I was told, as a sponsor of this bill, that for many, many Republicans, that they would make sure that I never won an election again in my life because it was so hated. And the same thing happened with Democrats. They were so hated for coming together on this compromise, which was so important. And just to remember the times, there was the Las Vegas shooting, one of the deadliest shootings we'd ever had, right? There was a concert, and a 64-year-old accountant killed 59 people and injured 527 others. And then there was the Baptist church where a gunman went in and shot 20 people dead, and injured 26 others. And there was then the Parkland, Florida high school shooting. So these things had just happened, and nationally, we were all saying, what are we gonna do? But red flag was already in many states, and Maine said, no, we wanna do something better. And what I really appreciate about this process is that it actually utilizes people's natural reaction when something they feel is going to go wrong. You call 911, you call law enforcement. You don't go to the court, try to figure out how to fill out paperwork, and get some sort of weapons restriction order. Yesterday, the courts were closed. It was snowing, but guess what? You could call 911 yesterday. So this is a very natural process. It takes advantage of what people will naturally do, but there's always an assessment. You're not just blindly asking a judge to take someone's constitutional right away without them having any information to go on besides one person's say-so that could actually be weaponizing it against them, right? They could actually be wanting to remove weapons to cause harm themselves. So this was deliberated so much in the legislature, and then just to sit and listen to your excellent overview of how it's being used now. This law has been changed every single year since it was passed. We have continually tweaked it, looked at how it's working, what do we do to make it better, and now we're where we are today. And really, I think just so many great iterations of this law. I'm surprised that it's not passed in other states.
Well, I think part of the reason, to answer her question, why maybe it hasn't been, well, first of all, before I say that, I want to compare state of Massachusetts and Maine in our law we have. State of Massachusetts has 7 million people. They've used their law on average about 11 times a year. About half those times, it's not effective. It's rejected by the court. You have Maine now that's using it, it seems 2, sometimes 3 times a day. And we're now at almost 700 times. But when you look at, my wife laid that out for me. She works for us once in a while. And she's like, wow, this is a lot. And it was engrossing to go read it and watch her read them. Those incidents up there don't have any names associated with them. But imagine from the police officer's perspective, from the family, that this is going on in our communities and we don't even know about it. These are individuals that are represented on those charts. They're people. They have family members, they have loved ones, they have children. And what is unique about Maine's law, and completely different than so-called red flag, is that our law takes that person in crisis, wraps their arms around, doesn't charge them with a crime. Our law says, hey, you're in trouble, you need help. Our law actually calls for that medical assessment, that link to services. So what happens is this individual who may have been in the state's database for years, having got a problem, suddenly there's an intervention. And every one of those people on those charts, there was an intervention to try to help them. Not take their freedoms away, but get them the help that they need. And that's what I think is so unique about our law and why it works so well. But to think for a minute, you're going to hear it during the referendum debates, that we need red flag. In Massachusetts, they used it once for every 1 million people in the state of Massachusetts. If you think that's more effective, then you don't know how to do math. So my point is that we have a good law, it has built-in protections, law enforcement is using it more, and we're getting more accustomed to how to use this tool. Why would we want to replace it with something that's so ineffective in Massachusetts? So in a little while, Justin is going to give a presentation, and you're going to see some clear differences between red and yellow flag and why I believe for public safety we don't want to go backwards. I do want to say one more thing. There's been accusations that our organization intentionally wrote a weak law. I'm a lawmaker of 12 years, 15 years as a lobbyist, and I've written some of the most complex policy our state has, including a mandatory reporting system for medical errors, conservation policy. When I work on legislation on behalf of SARE members, I don't intentionally weaken a law so that people will be harmed. That is insulting to all of the people who worked on this law. The only one goal that we had when we came to the table was saving lives. And finding...
Was the First Circuit said, no, that doesn't work, that's not due process, and it's not a commitment. It's emergency hospitalization, and
The important thing is our technical difficulties are fixed, but
I want to finish the thought. Nobody at that table, and I was there, so was John, so was Lisa, Senator, I should say. We were all at that table. Derek Langhauser, the governor, all of us had only one goal: build a law that could meet constitutional muster, had due process, had a link to services, and helped people. Not stereotyping them as owning guns, and we have to be terrified of them to take their guns away. It was about helping them. And I wanted to make that point clear, because I know I can speak for all of them.
all right, we had some technical, as you heard, some technical issues. Sounds like everybody's attached now, and we should be able to get that to work. So I'm going to jump right in,
Mike, awesome.
right into the first question here. And, panelists, does everybody here believe our law works as intended, the yellow flag law?
And you have some people on Zoom.
We should probably introduce them, that's a good
Yeah,
point,
sure.
yeah. John Chapman, you're on our screen, if you'd like to introduce yourself.
yes, hi, John Chapman here. I've been a lawyer in the state of Maine for 45 years. I've represented law enforcement for almost all of that time. I've also represented SAM, a bunch of large insurance companies, a bunch of individuals. I'm now representing a person who shot a deer to put it out of its misery on the roadside. So I do big cases and little cases, and I've worked with federal, I represent U.S. Border Patrol Services and some of their stuff. I try to get involved in firearms and law enforcement issues at every level.
Great, thank you. And I see Judge Carpenter, if you'd like to introduce yourself.
Sure. I prefer the title of former Attorney General or former Senator
Okay, apologies.
to the judge thing. I was Attorney General from 91 to 95. I was just saying to John before we got the technical difficulties clarified, the proudest thing, the thing I'm proudest of in my many years in the legislature would have been the so-called, I hate the name, by the way, the so-called yellow flag law that we put together back in 2019, 2020. So, yeah, I served quite a few years in the legislature, and then they threw me out in 2020. So, I'm in Bristol County practicing law.
I want to speak to Senator Carpenter's integrity for a moment. When we first came forward with the proposal, Senator Carpenter was originally working on the red flag. And he basically said to us, in the political world, they like to call you your enemies. They're not your enemies. But we met in a room and he said, hey, let's work on something. And that's how your government is supposed to work. It isn't, let's shove something down their throat because we can. Senator Carpenter, along with all the other individuals whose party affiliation doesn't need to be mentioned, all came to the table and said, let's work on a law. When you said that, Senator Carpenter, that it's one of the proudest things you've worked on, I can say the same thing. Because of all the people that are on that list.
There was no doubt. And I want to also give a shout out to the governor's office, because two people that are not part of this panel today that were instrumental, I would argue perhaps the most instrumental, would have been Brian McMaster, the longtime head of investigations in the Attorney General's office, and Derek Langhauser, who was, no offense to John or to anybody else, but Derek was the legal beagle that we had to get everything passed. He was the governor's legal counsel at the time. And those two guys worked tirelessly, along with the rest of us, to try to put this together. And it works. It saves lives. We've saved hundreds of lives, I believe, since the law took effect.
John, did you want to weigh in on this?
I occupy an odd place because many people on the left think I'm somebody from the right, maybe many people on the right think I'm from the left. But the big selling point, just as Judge Carpenter mentioned, is every time this law is used, it saves a gun owner who votes. And once people understood that, there was a huge aha moment in terms of the acceptance of what we're trying to do.
So with that, there are other legislators who are here that could interact, and other individuals in this room. Now is your opportunity. Not often do you get to open up the doors in Augusta in a room where deals are put together and policies made. This is your opportunity. The people that put this together are here. If you have questions, if you have concerns, now is the time to ask them. If you don't understand the law, now is the time to ask those questions. So with that, Penny?
Knowing that we're all sinners and we all want our own way, what safety, I guess, whatever, do we have in place that would keep a police officer from putting false information, or anybody in the party of action putting false information to get to the bottom line they want?
Yeah, sure, I understand. What levels of accountability are in place to ensure that this law isn't abused? And I think that's a great question, and it's one that will get debated in the red flag, yellow flag referendum, going back and forth. But I think that's a good question for you to answer, if you don't mind.
Sure. So
could you come up with
yeah. So I just want to make sure I understand your question. What guards against the abuses that could take place by law enforcement with this process, by maybe not either falsifying information or intentionally omitting information? Is that kind of your concern?
Not only law enforcement, but anybody that's party to the action, family member, neighbor.
So, and I welcome Ben. What I can, so when we talk about kind of due process, when you look at how this law works, there are multiple elements in it, or checks and balances, if you will. Law enforcement first has to make a determination based on if there's probable cause, and they do that based on their training, education, experience, and the policies that they have for the respective departments. So you could say that that's one check. And then they have to submit a written application, which is, for lack of a better word, well, it's not really an affidavit yet until it gets to the judge, but a written application, a document of record to a medical practitioner. And then you have a medical practitioner who, by virtue of their certification and qualification, is trained to make an assessment. And they have to review that and sign off on it before it goes to the next step. And then the next step is pretty critical. Then you have to submit that to a judicial officer, either a judge or justice of the peace. And they have to review, and now it is an affidavit that you're sharing with them and swearing to the truthfulness of what's in that affidavit that law enforcement has. And the judge or justice of the peace has to review that. So now you have an impartial judicial arbiter who's looking at it like you do with an arrest warrant or search warrant. And they review it, and then they have to sign off. And once they sign off, it then goes to the district attorney's office. And then they have to review it, and they have to determine whether or not that they're going to move forward, and they're going to have a hearing. They're going to file a petition to have a full hearing. Up to this part, everything's been ex parte. There's really been no opportunity for the person to be represented. Then you go within 30 days of that initial restriction, they're entitled to a hearing. And at that hearing, you go before a judge. So you go before a district court judge, and the district attorney would present their evidence, and the patient, who I'm going to call them, represented by counsel, would present their evidence, and that they'd have to listen to all the evidence, and you'd have to make a finding by a judge to determine whether you've met the burden. So I think that is the due process that we're kind of alluding to and talking about. Now, can you have abuses there? Yes, you can have abuses but that's no different here than in any other criminal process or criminal investigation. You try to guard against it, you try to ensure it doesn't happen. Does that mean you can ensure it never happens? No, but I think the steps you have in place, I think, minimize that, if not outright prevent it. So that would be my take from and as someone who's a troop commander, where I review these and I look at my troopers and I look at, you know, the accountability and did we do things the right way for the right reason at the right time? You know, that's also something that I look at. And what I find oftentimes is I want to make sure my troopers that are using this law when they're supposed to, hey, this was an opportunity, why didn't we do this? But so that I can speak to it from a state police perspective. Hopefully that gives you some comfort, but yeah, there's no perfect process because you have human beings involved throughout, but that's my thought.
You speak on like a false report, that is also a crime, correct? So if all else fails through the process.
Sure, so yeah, if any of this information is falsified, so I guess if someone makes a false report to law enforcement and it's determined in fact to be false, that is punishable by a crime. If you submit something on an affidavit and you swear to it and it turns out that you either made a material omission or you intentionally or recklessly falsified something, then you've committed at least false swearing, and that's a crime. So in addition to all the other, you know, my ethical and professional duties and responsibilities, there are certainly laws in place that criminalize that behavior.
You did such a good job talking about all of the different places in the system where there's a check and balance, right? And I think it starts with law enforcement, who have, and please correct me on this, a duty to protect people's Fourth Amendment and Second Amendment rights. And so...
And tell the truth.
And tell the truth, right? So they're out there protecting these rights. And anytime that we're looking at removing a firearm, we're asking them to violate somebody's rights. And so there has to be a certain standard of proof for them to even be able to start that process. I think that's the natural challenge that we have, whether it's yellow or red, is how do we make sure that we're preserving people's rights? In this case, it starts with law enforcement. And then with yellow flag, you've got that assessment by a medical practitioner. Now they give us all the information that they've accumulated, but we still have to do an assessment. And then we do that assessment and say, do we agree or not agree with that information? And if we agree with it, then they can go to a judge. And the judge will generally review that information and then sign off on it. Now at that point, you've got 3 separate people that are saying, this seems like a pretty good idea. And if you look at these, I would say, which of those isn't a good idea?
Plus witnesses.
Right. Like tons and tons of information. Now, that gets you 30 days. And that's a cooling off period, and it's important, right? That 30 days for some people is enough. For other people, it should be extended for longer periods of time, depending on the seriousness of the situation. And so to get past that initial 30 days, that initial kind of restriction, you have to, beyond clear and convincing evidence, that 7 on a scale of 1 to 10, the district attorney has to prove it in front of a judge, and you've got a lawyer. And so the critique of Maine system is that that's too much due process. But the other side of it is that we got a lot of due process that ensures it can't be approved, or can't be abused. Does that make sense? Yes. Yeah. It would just be really hard. You have to get a lot of people together, and you know, I'll buy into conspiracy theories, but that would be a hard one.
David, do you want to introduce your new people?
Yeah, go ahead, but Mike, why don't you kind of take over? I have some more questions you guys have.
Okay.
And also Senator. Yeah, just a minute, John, we'll get right to you. So Senator Shine has a question, but can you ask them to introduce themselves?
Yes, yeah, exactly. As David had asked, can folks that just joined introduce yourselves and let us know your part in the yellow flag?
I'm Dave Hagan. I served 8 years in the House, and now beginning my little tenure as a senator at the state level. I was a school teacher at the time also. I had 138 graders from Hamden in the Capitol on a field trip on a Friday when the Honorable David Trahan came and said, we need you in Mr. Langheiser's office. And I said, well, I'm giving a tour. I'm not here as a legislator right now. No, this is very important. We'll find somebody better than you. So I ended up becoming a person in the middle of the process. I thought that Then Senator Carpenter really led I'm on Judiciary Committee, was with Senator Kime and Representative Henderson. Currently, we are now. Senator Carpenter really led the committee very, very effectively and very well. High praise for him. Senator Kime was just fabulous. She's here and can talk for herself, but she was a great leader in the creation of the yellow flag. Law enforcement, Lieutenant Johnston, Troy Morton from the sheriffs, and Dave Trahan, just really, really, really attention to detail, taking care of business, and really dotting all the I's and crossing all the T's. It was an impressive process, and I'm proud that I was a part of it.
Good morning, everyone. I'm Rachel Henderson. I represent 6 communities in western Oxford County. I currently serve on the Judiciary Committee, spent the last 2 years on the Judiciary Committee. We did have the red flag law come before us in committee, thankfully. The legislature was able to kill that, but I know that we've got a lot of work ahead of us when it comes to preserving Second Amendment rights and gun rights. Just as a little plug, I obviously don't have the pedigree that the rest of the panelists do here. I'm getting ready, I just started in my second term, but really appreciate the way that the beginning part of this was presented with someone from the mental health side of things as well as law enforcement. And I think it's a really good visual aid of how this law is supposed to be implemented in the state of Maine is from mental health and law enforcement working together to ensure that the yellow flag law is implemented correctly, that an individual's due process is protected, their Second Amendment rights are protected, all while ensuring that we're providing public safety to the rest of the state. So I really appreciate Lieutenant and both of you being here to present that to us today.
Thank you. Senator Kime, I believe you had a question.
I did actually for the lieutenant. So it's one of the issues that has been a problem with the law, and I know it's changed, but I just wanted to have you explain it again, is if you can't get someone to willingly, so for instance, that scenario you gave with the mom saying, hey, the son that lives with me is suicidal. Well, she was open on allowing you in, but in that same situation, if you have a son living with a mom, but the mom says, no, everything's fine, but you have a lot of community reports and you know that things are not fine, and how do you get at that adult son living in that home? How would you now with the recent changes in the law?
So if I understand your question, I think there's, how do you establish probable cause if you maybe don't have the credible, reliable third-party reporting like the mother? And then maybe the second question is, if you do have probable cause, how do you physically gain access to the person to maybe do an assessment? Is that kind of your question?
Yeah, how do you physically gain access?
Well,
you're having conflicting reports there.
Well, it's a good question, and I don't know if I'm going to have a great answer for you because it's a little bit of a question for us. And ultimately, I may have to punt to legal beagles because I think if the question is, how do you gain access to someone that you have probable cause to take into protective custody when they're in a Fourth Amendment protected area like a residence? What legal recourse does law enforcement have? I think it's still an open question of law. I think it's fair to say whether the protective custody gives you that authority. So it's a good question. It's probably something that I would defer to the Attorney General's office on. What I can say is, when I have a criminal arrest warrant, that criminal arrest warrant gives me the authority to enter into someone's residence if it's the first person residence, means it's their residence that they own and live at, provided I reasonably suspect that they're inside. It was kind of an offshoot of a case called Payton versus New York, where if you have an arrest warrant, it carries with it the authority to go in and get that person. Now the question here is, does a mental health protective custody warrant carry with it that same authority? Now before law enforcement answers the question of whether we should go in, which is a separate question that can be influenced by a variety of factors, you first have to answer the question, can we legally? And so I think that's still something we're trying to work towards. Does this protective custody warrant give you that authority? Does it not? That is something that really hasn't been addressed, or I don't think there's been definitive clarification, so I'm probably not the one to give it. But it's a good question, and I think that may be something that may have to be litigated as we kind of apply this protective custody warrant and deal with those situations. Certainly law enforcement can enter into a house when you have probable cause in exigent circumstances. But that may not always be present, and, you know, we still would like to have a warrant because it's judicial cover when we go in and do something. So, now, practically speaking, if they're inside the residence, and you simply want to have face-to-face, you talk to them, you have a phone call with them, you try to work with family members, you try to, you know, if you really need to get an assessment on this person and you think that they're a danger to themselves or others and there's a dangerous weapon component, then, you know, there are other things you can do besides trying to force your way into the house. You know, what are their daily habits? Maybe they have an appointment every day. Maybe they go and run errands. Maybe there's another way that law enforcement can try to intercept or encounter them outside the residence. It's more helpful if you have family members that are working with you, but that's not always the case. But I think law enforcement would certainly still try to make an effort to try to maintain kind of, I say, contact. You're simply not just going to walk away and say, I hope things go well. You're going to make, now that we're in this post-Lewiston landscape, you're going to make sure that you maintain kind of contact with that person to ensure that when they do come out, that you're able to get them, take them into custody, and bring an evaluation.
We'll get to John, he'll have the last.
When you punted, John made a reaction, so he might
Okay,
have something to
so
say.
John, I'm gonna let you have the last word, but I do want to add something to what you said. Maybe I'll do that first, because you might put it in context when you speak. When Robert Card made statements that he wanted to do harm, there were 2 police reports that I've read. They were very lengthy and detailed, and I thought the deputies did a good job with them. Repeatedly stated that they did not want to be known as taking Robert Card's guns. The family didn't want to, because I believe they were afraid of him. But their statements and this is where Parsons splits the hair. Their statements that were made by the family and corroborated on multiple occasions that he was making more and more violent statements were there to establish the hearsay or the third-party informant probable cause for the purposes of taking him in for a yellow flag. And that's what the governor's commission identified. There was always probable cause because there's just so much evidence that he was becoming more and more dangerous. But don't get confused by people in the political world who want to make these assumptions that Robert Card's family would have done a red flag. They made it clear that they didn't want to. You're talking about a young man in school who's talking about his dad, going to a resource officer, which I believe is one of the most courageous things a young person could do. But they were afraid, and the family too. So these are very delicate situations that law enforcement deals with, and their daily decisions are critically important to public safety. So I needed to parse that out a little bit and explain it to you, that these things aren't just black and white. So go ahead, John.
A couple things. First, there's a pretty well-traveled area in administrative regulatory warrants out there, and generally, if they're for probable cause in an appropriate setting, you get them, and they're enforceable, and it's not a violation of somebody's constitutional rights to go in there. You have a neutral decision maker making a decision to authorize a warrant on grounds that are related to a regulatory statute. There's a ton of that out there. Everything from the Second Amendment regulating gun shops to building codes and so forth. It's not strange ground for any of us. The second thing is that we focus, of course, on the person, which these red flag laws do not, which is why they fall down a lot. I was taking a look at the stats in Maryland, and only about half of their red flag orders are granted. I mean, we have had one ever denied that I understand it happened. That's according to Ben Stritt. One ever out of about almost 700 now.
We're up to 3, John.
Half. So focusing on the person obviously gives us a big leg up on making this stuff work, and also developing the probable cause that we need. If you have some family member go in and as an uneducated person say some stuff, might or might not be enough to generate the probable cause you need to go after somebody. But here, we have law enforcement getting in at an early stage. By the focus on the person,
and not on just guns, you're more likely to develop what you need to get a disturbed person into custody. And it's obvious not only from the mechanics of the situation, but from the numbers. So I think we've got the right approach. And when you're listening to folks from the Maine State Police tell you how they do it, they're investigating a person. They're doing what they're doing just like they're investigating a person. And for example, if mom doesn't want to let you in, they're used to going to other people in a community and getting information, getting affidavits if they need them. You know, will you be willing to sign a statement? I am not, when you're willing to sign a statement, that's the kind of thing that can develop real probable cause in a criminal setting. And finally, the thing I note is when we put this thing together, I think of the senator, but now Judge Carpenter was part of this process. We looked at it as to handle those cases that the criminal process couldn't handle. If you do so much as threaten somebody with some kind of a credible threat or commit any kind of property damage or beat on a cat or a dog, if you attempt to do those things, if you solicit somebody else to do those things, you're already in the criminal arena, and this stuff that we're talking about, it's there, but it probably isn't necessary. You can just go to a magistrate and get a real criminal warrant, either an arrest warrant or a search warrant if they're in somebody else's place. So there's already all the criminal stuff that we have. If you do so much as attempt to do a bad thing, this only really covers the situations where there isn't a crime out there, but there's plenty of indicator that the person is decompensating, is likely to hurt themselves and others. We just use those same techniques to develop the same kind of information to get a warrant, and that, I think, is going to satisfy due process. We have it and nobody else really does. All they have is warrants to go get guns.
David, if I could just chime in also, just briefly. One of my concerns with a red flag, and I'll use John's statistics from Maryland, potentially you have the worst of all worlds. You have a family member going to court and failing to get a red flag order. So what you've done there is you have alienated the person who is potentially mentally unstable at the moment or whatever, or angry or whatever. You've alienated them and you don't have an order. So then you've set up a situation where the person who went to court in the first place could really be in danger. This is, I think, as John says, a much better approach. I'm going to have to leave here shortly, David, for another appointment, but I do want to thank you for having me, and it was a pleasure working with John and you and the rest of the folks, and give my regards to the new Senator Hagan. He served in my committee, but I haven't seen him since his elevation to the Maine Senate.
Thank you, Senator.
Thank you, Senator. And at this time, I'm going to ask Justin Davis to come up and join us, our NRA representative. And speak a little bit about the dangers of red flag laws. So,
No, you don't have to leave. Senator, you can stay as well.
You're welcome to
do questions and answers after.
Yeah.
If you'd like to stay, we'll do questions and answers after the
I don't believe so.
NRA's
I
presentation.
feel that just bring it up.
You'll want to stay, trust me.
Hey, Dave.
Thank you so much, the two of you did an amazing job. I appreciate your work.
Hey. My hometown senator. Senator David is here.
Did you watch my?
And my daughter's social studies teacher, right? Yes.
Thank you.
Hey, thank you, Dave, yeah.
You did a good job.
Call you later.
All right, yeah, sounds good, thank you.
So I sent you today,
You have it. We'll try to email you.
that's for,
You have a part of it.
He sent me something.
Just take a minute to get our electronic. You don't have it? I think you just drop the
No, I didn't. Hi, John.
We may have to drop you, John, so we can put the presentation in. If we do, call me on the speaker.
You're muted, John.
I'll go on speakerphone.
Okay.
All right,
Just
thank
shut
you,
it down.
John. Sorry about that.
Not a problem.
We'll get on technology.
Oh, we do have- And I think we can. Representative Mason just brought up that we will have a question and answer session when this presentation is done. So anybody in the audience who wants to ask a question, just hold it back, and when we're done with this presentation, we'll go to your questions.
Beautiful, thanks Dave. Can everybody hear me all right? Fantastic. My name is Justin Davis. I am a native Mainer, and I'm very happy to be here working with Dave. Before I dive into my presentation, I want to congratulate the Sportsman's Alliance of Maine and their members again on a huge legal victory yesterday in their case with 72-hour waiting periods. As probably already noted, we're facing an onslaught from out-of-state groups here who are looking to pass gun control. Many of you have been in this fight for years, and it's nothing new, right? You'll see Mike Bloomberg dump millions of dollars here to try to tip the elections because Maine's a cheap date on the political scheme as far as campaigns go. And without people like Dave, we would be in big trouble. Dave is somebody who can unify folks around issues, Republican, Democrat, in the 2A community, which I know can be a large spectrum as well. And without Dave, we wouldn't be here today. So I just want to take some time to thank Dave. The NRA appreciates everything he does. And because of his work and reputation, folks like the NRA and the NSSF are heavily involved here in Maine. So I appreciate the folks talking this morning about yellow flag. I wanted to dive in a bit here on red flag. As mentioned before, after the Lewiston shooting, the way Maine handles these issues really came into focus and it really highlighted the lack of understanding about red flag and yellow flag. And I'm going to apologize, you're going to keep jumping back and forth when I change slides, but it's just kind of the situation we have right here. But kind of the topic today is how extreme gun control laws allow bad actors to strip citizens of their Second Amendment rights and due process rights. So first of all, what are red flags? So-called red flags allow citizens to file petitions requesting the state to remove an individual's rights. These civil petitions are based on weak and nebulous standards, which allow the government to remove individuals' Second Amendment rights at ex parte hearings. If the petition is granted, an individual is stripped of their Second Amendment rights without any ability to defend themselves. And the really important thing to key on here that makes a difference between yellow flag and red flag is that red flag laws simply remove firearms from an individual and in no way address underlying dangerousness or issues with that person. They're not bringing the person in protective custody. They're not bringing those people mental health issue care, which they desperately need. Instead, it's just a deprivation of one's rights that's not based on a criminal conviction or a mental adjudication, but rather third-party accusations. Again, red flag laws only remove firearms from the situation. They in no way whatsoever address the person in need. They don't bring them in protective custody. They don't bring them into mental health care facilities. They simply show up unannounced, take somebody's firearms, and say, you've been ordered in 21 days, you have a hearing, you may be able to get your rights back then, you may be deprived for a year, good luck getting an attorney. You are allowed, under the way they're describing this law in Maine, to have a public defender. Many of you who've been in the legislative process know there's major issues with the public defender's office here in Maine. So that creates a further issue about due process rights. So how do red flag laws really work? So law enforcement or family members petition the court to remove an individual of their Second Amendment rights in an ex parte hearing. An ex parte petition is a legal proceeding where only one party involved in the case is present before the judge, meaning the other party is not given notice or the opportunity to be heard. Typically, a hearing will be held in 14 to 21 days where the aggrieved individual will have their rights removed if they don't have their day in court. But during this period, the defendant has no legal recourse to reinstate their rights. They simply have to wait an administrative holding period until they can plead their case. So as mentioned, so typically how red flag law works in other states, an emergency order will be granted, which will typically last between 14 and 21 days. And those orders typically last to about a year. It can be renewed annually. However, some states like California actually allow a 5-year deprivation of rights once you've been accused of a red flag. Now you do have the opportunity to protest that annually, but they are allowed to grant up to 5 years, which is pretty extreme compared to other states, which typically we see around 1 year. I think we've talked a lot about due process violations today. I don't think we need to kind of beat that dead horse here, but again, I just wanted to make a point that the deprivation of one's rights is not based on a criminal conviction or mental adjudication, but rather third-party accusations. So just because somebody has an episode or has been wrongfully accused of being quote-unquote dangerous, and they're unable to support their case after their hearing, or even before that, where they would have an opportunity to do that, you're removing many rights, not just the Second Amendment rights, which we'll dive into now. So one issue that doesn't get talked about a lot is how red flag laws actually impact First Amendment rights. An individual can be issued red flag order for simply expressing their First Amendment rights, and in today's hyper-partisan political environment, individuals can be ordered a red flag for expressing political views that may be seen as quote-unquote extreme, protesting government actions, or civil disagreements. Threatening to remove one's Second Amendment rights for exercising First Amendment rights certainly disenfranchises gun owners. And it is not just the NRA who believes this. The ACLU actually agrees with us on this issue. In Rhode Island, the ACLU put out a statement about their red flag law, about the concerns about how that can be used to tamper one's First Amendment rights, including red flagging folks who are engaged in quote-unquote overgrown political rhetoric on social media, how folks who are perceived possibly in criminal activity could be used to a shortcut seize lawfully owned weapons. And finally, which I found really interesting, was the idea that police officers and law enforcement could use it at protests or legal First Amendment gatherings to warn people, you better not do this or we'll be red flagging you and lose your Second Amendment rights. So you think of that in Augusta, right? When we have these Second Amendment rallies where people come from all over to about hunting rights, about whatever the flavor of the week is that week that Bloomberg's trying to take away from people's gun rights. Well, if they don't want them to there say, it'd be a real shame if all of you got your red flag order today. Now, a lot of people in this room may say, I'll take that risk and I'll still express my First Amendment rights to protect my Second Amendment rights. But that certainly is a deterrent for many people. So it provides a huge, huge, huge overstep of authority for the government, both federally and state level. Now, of course, it also violates Second Amendment rights, right? So you're taking away somebody's firearms, their constitutional rights on something that is not a criminal conviction, a mental adjudication. This person is not technically prohibited at that time, simply based on hearsay. So for 14 to 21 days, you have absolutely no legal recourse. The state can come in unbeknownst to you in the middle of the night, make you aware that you have been removed of your Second Amendment rights, and you have an opportunity during that period to obtain legal representation, and hopefully you have a successful hearing, and hopefully you don't have to wait a year. And so during that time, those folks have no legal recourse. They have no way to regain those rights, and puts them, both their families, at danger if they feel the necessary to protect their families. But also, we're talking about major property, right? So some of these firearms cost several $1,000s. They may be family heirlooms. They may be passed down. Now, I know a lot of people probably think that when those firearms are taken, they're put in a nice gun safe, or a nice Liberty safe with a nice humidifier in there to protect those. If you've been in an evidence locker room, I can assure you that your prized possession, your family heirloom, grandpa's Winchester repeater, is not being taken care of the way you'd like. So that puts the state at liability as well. What happens if those get damaged? What happens if they get lost? There are a lot of administrative issues as well that we'll dive in on that. And of course, there's Fourth Amendment rights. The defendant has no right to legal representation at the ex parte hearing. It creates search and seizure violations once the red flag is ordered. Police are ordered to the defendant's home or when they're in public to demand all their known firearms, search their home, confiscate all known firearms without prior notice. And essentially it's creating new stop and frisk policies, right? So if folks wanted to abuse this, they could say, hey, we think so-and-so is a problem, let's red flag him, let's see if we can go in and see what he has. Maybe he has contraband, maybe he has firearms, maybe he has drugs, maybe he has anything that they want to use. So it's basically a sweeping tool that allows the government to violate one's rights without any recourse. And of course, there's Fifth Amendment rights that doesn't get discussed very often. So once these ex parte orders are issued, you are in violation of owning a firearm, right? Unbeknownst to you, from that exact moment that that's ordered, you have now are actually technically creating a felon act by owning that firearm. And when the police show up to your home or in public and say, give us all your firearms, you are required to tell them everything that you own. If not, you'll be in violation of that order. But the simple act that you already have those firearms and you're self-incriminating yourself, saying, I own these firearms, they're in my home, even though I'm a technically prohibited person, creates many Fifth Amendment concerns. And those folks who decide to, roll the dice and say, I know my rights, I'm going to not self-incriminate, could lead to further criminal offenses and legal penalties, including jail times, fines, and further restrictions. As mentioned before, this creates a ton of administrative issues for the state. Red flag laws lack clear direction of how to transfer, store, and care for surrendered property. Some folks have said, hey, you can give it to a family member. Some folks say you have to give it to the state, you have to give it to an FFL. These laws are typically written with no input from these stakeholders. I can assure you that FFLs do not want to take in firearms from people they do not know who may be a danger, who may be a problem. And then the state likely doesn't want to take it because it puts them at liability. They don't want to be in the position of storing thousands, possibly, of firearms that could be of immense value, and then be in a legal battle about it that if issues happen to that firearm. So say, you have a 100-year-old firearm that was passed down to your family, that's of important nature to you. Now it's rusted and beat up and dented and lost all value, or maybe they just can't find it. It's in the evidence room and sorry, we can't find it. Well, what's your recourse as a defendant there? The other big issue is that there's no guarantee once you're red flagged that you'll ever be able to buy another firearm again. Typically, red flag orders get reported to NICS, the National Instant Criminal Background Check, run by the FBI, where you have to use to purchase a firearm through FFLs, and now it remains new background check laws for any advertised sale. So if I want to go buy a firearm from Dave and I was red flagged a few years ago and I think I'm good now, my order's gone away, we go down to Cabela's to do that transfer and we're told, I'm sorry, but you're a prohibited individual. And I look into it and they say, well, you've been red flagged. Well, my red flag order was taken away, it was erroneous, there was no reason for me to have it. Well, NICS doesn't know that. And if any of you had a deal with NICS or trying to get any records taken away from NICS, well, good luck. I hope you have a good lawyer and a whole lot of money and a whole lot of time to do it, because there is no process and no guarantee that you'll be removed from that list. Furthermore, just because one was filed and one ex parte issue was ordered, you may spend the rest of your life a prohibited person with your Second Amendment rights completely blocked. I think this is super important. So we've been doing a lot of research, and we found a study from UC Davis in 2020 regarding California's red flag law, which is one of the more extreme laws in the country. And the study looked at how does red flag laws impact minorities and people of low income and people who may have been perceived as a target of the police, right? And so that study looked at how does red flag laws in California interact with minority communities? And here's what they found. This is from UC Davis. Not a place that you'd expect to agree with the NRA many things. No Black or Hispanic or Latinx individuals who are subject to an IRPO had family or household members submit that petition. Not a single one. Compared with other racial ethnic groups, Black and Hispanics individuals subject to IRPOs were more often arrested at the time the order was served than their counterparts. And Black respondents were also less likely to have documented firearm access and legal representation at IRPO hearings. So at a time where we're looking at, how are people who are low income, who are maybe disenfranchised or not have the same equality in the legal system, these red flag laws can be absolutely used to target those individuals. So you're seeing a lot more groups who represent minority groups who are raising this concern. We talk a lot about we talk about many issues about public safety, and folks have brought up the concern about how it impacts folks in these communities. Well, red flag laws, if you're worried about the expansion of rights, or lack thereof, taking away individuals' rights for these communities, red flag laws should certainly be of concern to you. And I want to do a couple case studies, right? So I want to choose a not perceived Democrat state. Massachusetts is pretty strong Democrat at this point, and a perceived red state, Florida, and kind of how these states handle red flag and how they played out. In Florida, from 2018 to 2022, 97% of red flag petitions that were requested were ordered at ex parte hearings. So essentially, every single one, pretty much, has been, if you were filed a petition for an ex parte hearing for an emergency removal of firearms, that was granted. Polk County has, which is the highest rate of red flags in the state, is petitioning, red flag petitioning children as young as 7 and 8 years old. Let me repeat that. Children who are not old enough to drive, children who are in 1st and 2nd and 3rd grade or in elementary school are getting red flagged by police officers, by the sheriff's office. They're showing up at their home, removing firearms, I guess, from 7 and 8 year olds, and giving them a lifetime stain on their record of having a red flag. When you go to join the military, when you go to get a college education, when you do anything for the rest of your life, an 8-year-old, because he said something on the playground when he was in a scuffle, could have their entire life changed. And it's also disproportionately used throughout the entire state. Depends on where you live is your likelihood of getting red flag, and we're going to dive into some statistics here in a minute. But it's not a blanket thing, right? It's not like we're seeing in Maine where there's pretty proportional use that's happened post-Lewiston. This is where basically if you have a sheriff who's gung-ho and wants to really expand his power, you're seeing a lot more red flags take place. And in Massachusetts, Dave touched on it before, Massachusetts is home to the most extreme gun control in the state. They realize their red flag, their quote-unquote standard red flag that they want to implement here in Maine is not working. So what have they done? Their recent gun control bill, they've enhanced red flag. And they allow over a dozen classes of individuals to file a petition against another individual for red flag. So we go back to the First Amendment issue. You know, I would say school board meetings have become a center of concern for a lot of people where they're getting heated to discuss what's happening in their children's school. Well, somebody says something they don't like in that school hearing, they may get a little heated. Next thing you know, you go back the next day, you're red flagged because of what you said at that hearing. So, you know, we're seeing these classes get built up very far. In Massachusetts, you have school officials, you have healthcare workers, you have public safety individuals. Basically, anybody who works in a government stance at this point now is able to file a petition at any moment. And again, as you see in other states like Florida, if that's filed, judges almost nearly always accept it. So this is a report from ABC News in Florida that showed that 97%, like we mentioned before, these red flag petitions were accepted. The Polk County Sheriff's Office was red flagging children as young as 8 years old and examined how many that happened. So 450 children have been filed red flag petitions during 2018 to 2022, and that was increasing. And ABC News found that the law that was created to keep guns away from Floridians who threatened to hurt themselves or others was being against use kids who could not legally drive to their court hearing, while others were barely old enough to sign their name. So that took effect in March 2018. Had filed RPOs against children as young as 8, 9 years old. The sheriff had said, when asked about it by the news, he said, if you're old enough to threaten somebody, you're old enough to be held accountable in court. So these are 8, 9-year-olds who are just, again, maybe having a scuffle, maybe saying they say something they shouldn't in court, but now are being held through an ERPO for up to a year. Their families being held hostage by this situation, and now have the rest of their life ruined because of something they said when they're 8 years old.
Justin, what is the age to own a firearm in Florida?
I believe it's 21. Yep. So yeah.
So that child that just got red flag cannot own a firearm.
Correct.
Cannot purchase a firearm.
Correct. For 13 years.
And some of the research that I looked at actually said that in some of these households there weren't any firearms.
Correct. So these red flag petitions do not mean that someone owns firearms, right? There's no way of them knowing. There's no gun registry that says, you know, Justin Davis owns X firearms, we gotta go pick them up. These are simply hearsay. This is saying an 8-year-old threatened my son, I want them to go to the house and take all the firearms to the family because I feel threatened. And
So aren't you actually red flagging the family?
Correct. And also under federal law, just because an individual is prohibited in the home does not mean that everybody in that domicile is prohibited, right? So if you have a son that was arrested and is now prohibited, does not mean that you as a father can no longer own firearms. However, the use of this red flag law with minors is saying that if you're going there and you own, because the child's not owning firearms 8 years old, as they shouldn't be in Florida, and they're going after the family as well. And here's a really helpful view of when we talk about disproportionate use throughout the state. So as you can see on this map, there's the frequency rate of red flag petitions being used throughout Florida. And Highlands and Polk County are among the highest users per capita. As you can see, the yellow circles represent the per capita use versus the red circles that are just the total frequencies. In Polk, which is the sheriff who is red flagging 8-9-year-olds, is one of the highest, and Highlands is way outside the mean here. The mean is actually 0.362. Highlands is using it 3.152 per 1,000 citizens. So I highly doubt there's anything happening in Highlands specifically that's creating a near that kind of disparity. So again, depending on where you live is how you're impacted by this law. And we're lucky in Maine. So in these super partisan times, there's very few opportunities where folks kind of come together. However, red flag is one of the places where it does. Year after year, anti-gun advocates introduce red flag bills, and year after year they fail. This is thanks to a large coalition of bipartisan lawmakers who understand the real risk of red flags and their constitutional rights. Red flag has such a lack of support in Maine that progressive leaders could not even run on the floor last session. And in our State of the State address, Governor Mills noted that it would undermine Maine's current law. And so, there's actually, we actually just ran, Dave, myself, and Laura Whitcomb over at Gun Owners of Maine, actually just run an op-ed in the Portland Press Herald after the editorial board decided to make the issue of guns a completely partisan issue, which just isn't true, right? If you look at, Maine's been Democrat controlled for quite some time now, yet we've been able to block many anti-gun laws. And I think this is kind of the biggest one that you see of folks coming together saying, I'm putting the partisan issues beside, I'm putting the outside lobby beside of the Bloomberg groups, and saying, what is this impact on public safety and constitutional rights in Maine? And there's no bigger danger to Maine than red flag laws. So what can we expect next with the red flag referendum? The proponents will run an extremely well-funded persuasion campaign run by out-of-state elites. They'll run an aggressive media campaign filled with TV, digital, and print ads distorting the truth about red flags, and they'll prey completely on emotions instead of facts. So as we go here across the next year, and we work with Dave, and we work with you and our SAM members and NRA members, we need to get the word about the facts and the real dangers here. I think when people hear about the way red flag issues impact minorities, people who are low income, people who are 8 and 9 years old, 8 and 9 years old, the rest of your life stained because of something you said, because the sheriff said that you need to be red flagged and your family can't own firearms on hearsay and weak and nebulous standards. I think that's too extreme for Maine. I don't know who wouldn't think that, but we're ready for a fight. We're ready to take it to them, and we're going to stick by our word. We're going to stick by the facts, and bring a well-organized campaign to protect Maine from these egregious rights violations. So I'm happy to take any questions there may be. Turn over to you all.
At this time, there are some folks that indicated they had questions. Go ahead and you can the legislators can join us here. If there's any more legislators who want to come up here. But anyone who has a question, now's the time to answer it.
You're in a real friendly room. How are you going to address the people down in southern Maine?
Yeah, absolutely. So I'm actually from southern Maine, so I have a lot of good connections down there. I can understand what people think about this. And I think we got back to the partisan issue of this, and people think that all gun rights issues are partisan. They're really not, right? So there's a massive, massive amount of Mainers who own firearms on all sides of the aisle. Left, right, poor, rich, no matter what your background is, people own firearms in Maine. And so when we talk about this, I think we have to bring these real facts that touch people. I think a lot of times as gun advocates, we kind of get stuck in this mode of saying, due process violations, Second Amendment rights violations, and that's true. But we need to tell the story of real issues, how this has been impacted. We need to tell the stories of Florida families who have had their lives ruined because of an erroneous red flag order against their child. We need to talk about how this has impacted people in California or Massachusetts who may not be able to represent themselves in court, and tell these real life stories. I think I'll give the credit to the anti-gun groups. They've done a fantastic job of storytelling over the last decade. We've been stuck on facts, and facts are great, but we also need to be telling stories about how these real life Mainers will be impacted and bring that story to them. And I think with the right persuasion and the facts, I think we'll be highly successful.
How are you going to hit them?
I think more will be coming out about the strategy on the campaign. I don't know if this is the correct forum to discuss it now, but I'm happy to talk with you off mic about what we're looking at.
I want to back up for a second. There's some smart people in this room. When red flag laws were created, it was specifically to take firearms away from dangerous people. An 8 and 9-year-old cannot own firearms, cannot purchase them. How can a red flag law apply to an individual who can't own and possess and purchase firearms? When I saw that headline, I was just in shock, and this is why. Most people don't know that in Florida, juvenile records are not sealed. So if a red flag is conducted against an eight-year-old child who said something on the playground, that's going to follow them in their record for the rest of their life. You just changed the course of a child's life. I'll ask you this, many of you are parents. Do kids know the consequences of their statements? I know my brothers and sisters have said some pretty tough things to me over my lifetime. And should that alter a child's life? And lastly, an 8, 9-year-old can't even buy a firearm until they're 21. So ask yourself this, why would a sheriff in Polk County apply red flags to children? Ask yourself why and how. And I'll give you the answer to that. It's because they can. And red flags allow a person's personal feelings and opinions to dictate who gets red flagged. You heard this morning how our process has built-in due process protections to ensure that a person's opinion doesn't destroy another person's life. That is the distinct difference between red and yellow flag. Based on a person's activist sheriff or an activist, we've seen it, attorney general in some states, if you can get an activist, anti-gun sheriff elected, you just gave them the power to ruin people's lives. That is, I think, the scariest part to me, is you're giving this immense power to people with a political agenda.
And to build off that, Dave, I think if you look at the trend and kind of what's happening in the main political scene, especially with our DA races, I mean, you're seeing massive amounts of money being spent by outside groups to get people of a specific political designation into these DA offices. And, you know, if you don't think that that's not important, I'd suggest you open your eyes on how that will impact this as well.
Some questions?
David?
Yes.
Just want to mention some efforts that we've made. We've actually done quite a bit, and it was rebuffed by the people in my party. I'm one of those strange pro-gun Democrats. I drive a Prius, and I'm a lawyer, and live in southern Maine, and you'd think I'd be the Antichrist, but I guess maybe I'm not. But we've actually done a lot to try to have an arrangement where it'll be regularized and inspected. If you've got prohibited people in the house, the rest of the people don't have to forfeit their Second Amendment right. And that was rebuffed by the Speaker of the House, which to me is absolute madness. Yeah, we're doing this to protect you, but we don't want to actually protect you. And I think that's the agenda that's going down here. The one thing that I think should also be said is if little kids have possession of firearms in an adult's home, you don't need a red flag process. You've got endangering the welfare of a child now under current law. You can get warrants for arrests of those parents. You got probable cause to believe that.
Absolutely, and I think that's an important point, is that there's plenty of opportunities to address some of the issues of these concerns, right? So if somebody's truly endangering themselves and others, bringing them in protective custody, making sure they're not hurting people, they're not hurting themselves. By simply going there and taking their firearm and saying good luck, I mean, look at what's happening in other parts of the country and around the world with some of the issues with vehicle manslaughter, knife attacks. I mean, you're not taking that person out of the equation, you're simply taking guns away as a feel-good measure for yourself. So there's plenty of opportunities, whether it's a criminal conviction, mental adjudication, protective custody. Do it the right way. I think that's the important thing. And I know Maine is working very hard on that to make sure we get that right. And just throwing all that out to pass a boilerplate Bloomberg law that's been used in California, Massachusetts, and other states is not the right way for Maine, I don't think.
Any more questions?
Just one, is our yellow flag on the radar of any other states right now? Are they looking at what we're doing?
Yeah, I'd like to speak to that.
Yeah, please do.
When this law first passed, what I said publicly, what I said to the frontline reporters when they interviewed me for 3 hours for that frontline piece that they never even got a single comment from me that they did on TV, was that
had the Gun Safety Coalition embraced what we had done, this could have been a model for the other, 30 states, almost 30 states that do not have this type of law. There are, we all know it, there are liberal states, there are moderate states, and then there are conservative states. For those moderate and conservative states that don't have anything, this could have been a tool that not only has the due process, it has been tested in Maine Supreme Court and determined to be constitutional. So their almost obsession with checking the box to get red flag in Maine, they have buried their head in the sand, and they have missed an opportunity to go to those other states and say, hey, it worked in Maine. It has due process, it's been tested. This is an option for you. But keep this in mind, they don't want to do that because it's not part of their agenda. I have found that the Gun Safety Coalition has a box that they want to check each session. Whether it's a 72-hour waiting period or magazine capacity, red flag. That's their agenda. And they don't see a better wheel being made or a better law like ours as success. They see it as a loss. When you look at those charts with 672 people who have been helped by our law, I ask you, is our law better? Is our law working? Is it saving lives? That should be the only thing they care about. But they don't. They only care about winning. And in this case, what concerns me is they'll say just about anything to confuse the Maine people. And we're going to have a discussion around the state of journalism in Maine at the end of this day today. I encourage you to stay because without independent journalism, without people fact-checking what we've been saying, how are people in Cumberland County and York County, who have the two heaviest populations in Maine, going to learn the facts when the Press Herald, almost a year prior to the referendum, are already railing against Maine's law and calling for red flag without even knowing the facts, without listening to the debate? They've had their own editorial to scrap what they call scary or whatever that was, terrifying. They called Maine's law terrifying. They labeled it. How do we get to the facts if we aren't pushing back? And in this case, the facts are on our side. That's why you'll see more and more in these events. This is a complicated issue. But without a truly independent press to bring out the facts, Maine people are potentially going to be voting on something that could cost lives. You think about it. If they're successful in supplanting our law, used almost 700 times, and go to this red flag, and they stop doing these that you see over here, do you think the public's going to be any safer? No. Our communities are going to be dangerous, and people are going to die, be harmed, and commit suicide because these people have their head in the sand, and they only care about winning. And that's the frustrating part for me, is that we did something amazing, it's saving lives. Why in the world are we even here? So that's my thoughts on it. I'd be curious to see what you guys think of that, but it seems nuts to me.
Well, it's a huge attack on our firearms and our rights, our Second Amendment rights. One concern that I had going into the yellow flag, yellow papering process with Senator Kime and David Trahan here, when we were with Attorney Langhauser, was under red flag or what have you, my guns, when they confiscate my firearms, I've been deemed a harmful person to myself or someone else. Where do they go? Well, the law enforcement has a steel container out back, not air conditioned or what have you. And the guns or firearms, when you get them back in 5 or 8 or whatever years, are just a big thing of rust. I said, well, I have 50 firearms for deer hunting, moose hunting, all that kind of thing. I love hunting. My wife and my son more so than me. So if I'm deemed a hazard, do all of my 50 firearms that are confiscated go to this lockup and they're ruined? My wife loses her right to be able to go deer hunting, and my son? I'd like a fix here. And what they determined was that if my firearms are taken from me, maybe they can go to Senator Kime's house she'll take care of them, and there'd be repercussions under the law for her if she gave me them back, and therefore they're properly taken care of. The fact that they might go to a gun shop, I asked the gun shop folks, we don't want them. We don't have the room for them, that's not something we need. So under the yellow papering, they really took care of good detail to safely get the firearms away from me until I can be deemed not harmful anymore, and then return to my house and my wife could go over to Senator Kine, get her firearm, go shoot a deer, what have you, and whatnot, if you want to.
No, I think you're absolutely right, Senator Hagan. And I think one of the big problems here is that the folks who are pushing these laws, they just don't understand firearms or how they're stored or how they're kept, or they just don't. They're afraid of firearms in many cases, right? They don't want people to own firearms. I've been told by these people to my face that they wish the Second Amendment was just repealed straight out, right? I mean, I don't think that started from a good faith effort to find a reasonable ground here. And so when people have so little experience or knowledge with them, it's not surprising to see they don't think of the aspects of how are these going to be stored, how are they going to be transferred, how are they going to be transferred back? Do you have to go through you have to go through another background check? But now it means waiting period law. You just got found that you were erroneously charged with a red flag order, and now you have to get your property back. Hopefully it's in good condition. Now you got to go to who knows where. Maybe they're stored in Augusta, and you live in Madawaska. You got to come down to Augusta, run your background check. You got to wait 3 more days, go back. I mean, none of this stuff is fleshed out, and they don't have an interest in it. And to build on Dave's point as well, is that these are not ideas unique to Maine. I cover Maine, New Hampshire, Vermont, and Mass. And the same things that they're pushing in Maine are the same thing they're pushing in Vermont, the same thing they're pushing in New Hampshire, and it's just a national agenda. They don't sit down, they don't talk to these folks about, they don't meet with guys like Dave, they don't meet with folks like you to say, hey, what's really going on here? It's a political agenda to disarm and disenfranchise Maine gun owners, to reduce the amount of gun owners, to reduce the power that the voting bloc has, to protect the rights of constitutional Americans. So it's a grave outlook for what's happening next. You're going to see a ton of money poured into this race. You want to talk about a blank check? I mean, look what's happened before. With the bear baiting referendum and background checks, the only way to beat it is through grassroots, through working hard, getting involved with your local club, paying your SAM member dues, finding ways to help out. So, and I'll be here. I'm happy to talk with any of you. We're standing by with Dave hand in hand like we do on all these battles. You're in good hands with Dave here on the show. So.
Yeah, I was a sitting legislator at the time of the law, and I want to just publicly thank both Senator Kine and now Senator Hagan for keeping the caucuses in the House and in the Senate aware of what was going on and the hard work they worked on this bill. There's no question about it, and all of those that were involved in it. Because by doing that, it allowed it to be a lot easier to get this passed through than it would have if we wouldn't have had the knowledge and the information coming back. I know Dave spent a lot of time in our caucus talking to us, and I'm sure Senator Kine did the same thing in the Senate. And I really appreciate that, and appreciate all the hard work on this. And having been a law enforcement officer for 40 years, I realize how important this bill is.
So are there any more questions? Well, we have a really nice lunch that's going to be served, and if Kim, you want to let Betsy know, she can start setting it out. I'm going to pivot to the 72-hour challenge that was initiated, and we got a judge ruling. So some of you may want to ask questions. Oh, Kevin, go ahead. Sure. Yeah. Thank you to the press that did show up, by the way. I see Kevin, trusted member of the press. Any criticisms I have are not for him.
That's good. I can take it there.
Yeah, I know you can take them. There are some really good press people. But, I want to take an opportunity to address the 72-hour challenge because some of you may have questions. I want to give you a little history on that. Maybe you can just hold off on your questions for just a minute. After the Lewiston shooting, it was obvious to many of us that there were going to be gun control measures come forward. The 72-hour waiting period was kind of like on the horizon, and it wasn't something that people were worried about. we dealt with, and most people don't know this, the Speaker of the House had a mental health bill to expand services into rural and suburban areas. And she could not get that passed in the House with Republican support. The governor also had a mental health bill in her, and I guess it ended up maybe in a budget, but in both cases I was asked to assist both the Speaker and the governor on those mental health service expansions. Part of our problems around mental health is that in Cumberland County, you can get services pretty quickly. But in, say, Piscataquis County and Aroostook and other more rural counties, those services are non-existent. So I helped the Speaker. I amended her bill in 5 different places, along with Representative Falkingham, to assist her in getting that passed through the legislature. And then assisted the governor with her mental health expansions. I bring this up because in the context of all of the work that we were doing, including changes to the yellow flag law, one of the last things that was done was the passage of this 72-hour waiting period. It came out of the blue. It was done under questionable circumstances, arm twisting in the House, and manipulation, and then vote pairing in the Senate. I was a senator, 2 terms. I had never seen such a tactic used, where 4 senators could switch votes to get you to a majority. They actually had agreed to have their votes discounted. So 38,000 people that they represented, those 2 senators, were not part of the vote. So that 2 other senators could have their vote count and get it over the top. I was in the chamber when it happened, and I said, you know what, that is not how government is supposed to work. But they got it passed. I want to tell you this. Months prior, I was meeting with leadership, the governor and others, and saying, waiting periods are unconstitutional. If you pass it, we will challenge it. No one saw it coming. The last minute it passed. So fast forward to the challenge. Why the challenge? Let me tell you why, at my core, I know this is wrong. When you've been vetted by the government, you're a law-abiding citizen, you've had a background check, a waiting period is arbitrary, meaning that you have to wait 3 days to exercise a freedom that's been vetted by the government to meet what goal? If you apply that to all of our freedoms, maybe the government can pass laws that say Kevin Miller can't exercise his right to be a journalist until he's been vetted by the government and waits a period of time. That's not how the Constitution works. So yesterday, I should say who was involved in this. There are attorneys at Clement and Murphy. These attorneys are the best in the country. Clement and Murphy argued the Bruin case in front of the Supreme Court. And the Clement part of that actually has argued more Supreme Court cases than any lawyer, public or private. He is a rock star and a winner, and nobody understands, I believe, constitutional freedoms than he does. He is our lawyer. Nobody saw that one coming. When I say he's our lawyer, the National Shooting Sports Foundation secured Paul Clement and his firm. They are the best, and we saw that in the ruling yesterday. I guess it was yesterday, when the court basically annihilated the whole bill. If you read it, it's one of the strongest worded rulings that I've seen in my time in politics, reinforcing what I just told you. Arbitrary waiting periods are unconstitutional for all your freedoms. You have to have a reason to do this. And it was a stretch to say that it was to reduce suicides. The law that actually reduced suicides is on that wall. There are hundreds of people in states of wanting to commit suicide that were saved by that law. That's how you do it. So, that being said, I bet there's some questions from you as to what happens next. I'll ask you if you want to, anybody have any questions at this point on this law and where it goes from here?
What happens next?
Well, if you've got endless pocketbook and you have lawyers that you can sick on every level of the courts, what happened the other day could be challenged it could be appealed to the next level, in which a judge could remove the stay. We expect that that may happen, but that comes at a risk. So if early as next week, there could be an application from the Attorney General's office to repeal the stay. If that happens, the law goes back into effect until the case is resolved. What struck me was how insulting the Gun Safety Coalition was to Judge Walker. They criticized him as being a Trump appointee, a LePage appointee, and questioned his integrity. That's not how our judiciary works, people. They're an independent judiciary, they're appointed. But once they're appointed, they're meant to be impartial. That's our judicial system. These individuals questioning the integrity of a judge is below the belt. They didn't question the components of his ruling, they questioned his integrity. I'm here to tell you that we don't do that in Maine. This is something that happens in Washington, D.C. It's a cheap shot and it's below the belt. Judge Walker, using that logic, any Democrat-appointed judge, you should see any ruling as partisan. For Judge Walker's cases, you should see every one of his rulings as partisan. It doesn't work that way, people. This state has been Democrat for over 40 years. Using that logic, every judge appointed by a Democrat should be questioned as partisan. That's not the way we do it. So that being said, the next step is we're going to wait the Attorney General's ruling on whether they're going to appeal. If they appeal, we have the funding to go all the way to the U.S. Supreme Court. And at that point, if that happens, this will get settled for over 20 states. And if it gets, I guess, reinforced at the Supreme Court level, all of those laws will then be null and void. So this could create precedent for the next 100 years on whether waiting periods are constitutional. No question? God, it's easier to travel. I've ever worked with. There's no questions on this? I guess I'll leave you with one last thought around this right before we eat our lunch, is that in our highly partisan world that we live in, it has become more and more difficult to come to the table and work on policy on both sides. What I saw for the people that worked on our law, it took a lot of courage on both sides, because we were being beaten to a pulp politically on both sides. We were called turncoats. People were threatening a petition to have me ousted as executive director. On the other side, the gun control people were tearing up Derek Langhauser. It took a great deal of courage for everyone to stay at the table. But we believed in what we were doing, and we got a good law. That is now not common. It's the exception. And that's sad, because once you get to that place, you can't solve problems. Did I want to get up there and negotiate? No. But you have to. If you don't, our government fails you. Because we have to solve problems. So I'm going to leave you with that thought. We do have a lunch. Please help yourself. And right after lunch,